I begin by acknowledging the Kaurna people as the custodians of the Adelaide Plains, on which I am recording this podcast today. I pay respect to elders past, present, and emerging. I record this podcast to actively take responsibility for the law that I am studying. I really want to understand how struggles for justice take place. Heart Podcasts 2023 Australian Indigenous Voice Referendum Bonus Episode. Welcome to yet another bonus episode of the Heart to Heart Podcast, a student-led legal podcast dedicated to exploring the referendum on the Aboriginal and Torres Strait Islander voice. I'm your host, Noah, and we are thrilled to welcome Dr Dylan Lino, a senior lecturer at the University of Queensland Law School, to our podcast. With a focus on constitutional law, colonialism, and Indigenous rights, Dr Lino's research has left an indelible mark. His instrumental role in shaping the Uluru Statement as a technical advice to the Referendum Council's regional dialogues and National Constitutional Convention, and his numerous prestigious awards, like the 2020 Paul Burke Award, highlight his profound impact. Join us as we explore Dr. Lino's insightful perspective on reshaping society through research and the imperative of constitutional recognition in Australia's political landscape. We'll elaborate on some of the key points voters need to know to take responsibility for understanding and challenging the role of settler law in creating the present situation. Discussing and thinking about constitutional law and Indigenous perspectives is like navigating a maze of legal concepts, and I am really keen to clear up a lot of my own confusions picked up along the way. I mean, reality is sometimes flipped and presented as its opposite. Normal functions of our democracy are being presented as dangers or undesirable outcomes. Reliable information is harder to source, but luckily there is generally a lot of material from universities and the government. Just imagine the confusion caused so far, because law is so removed from what we do daily. So tune in, folks, because this podcast episode is about to be yet another crash course about the voice and constitutional law for both you and me. Picture a scenario where Australia is invaded and the rights of the Australian people were violated. That's exactly the historical experience of Indigenous people who had no say in welcoming the settlers or their foreign culture. It's distinct from subsequent migrants who willingly came to Australia and blended into the larger Australian identity. As we reflect on this history, it prompts us to ponder questions like, how do we address the consequences of the past? Is the voice entrenching victimhood? Is there a preference for assimilation, overlooking ongoing disadvantage, a resistance to reinterpreting history, or abandoning terra nullius? Are we already reconciled? Or is no reconciliation possible on the basis that Indigenous settler mutual recognition and respect has never occurred in the past? Or could the voice be reconciliation if certain events since 1967 were signs of friendly relations, and after self-determination, as it was considered back then, was shelved as a failure and destroyed the friendship, we are now re-establishing ongoing recognition by listening to Indigenous voices? Is there no gap to close? It's confusing to have the same words hold numerous meanings depending on who is using the words. For example, equality. Equality before the law. Equal voting power or value. Equal representation. Equal before government decision makers. Racial equality. Substantive equality. Formal equality. Equality of treatment. Equality of opportunity, and so on. As for detail, it could be referring to the voice legislation or a trial of the legislated voice to see its operation in practice, or the lack of detail in the Constitution, which isn't designed to have detail, or something else. Just on the issue of detail, too much certainty on a proposed model makes the referendum much more difficult to achieve success. If information is all that is needed, there's way too much to read. Many options, many opinions from various experts and bodies. I've compiled my personal list of open access online sources, and I'll include a link in the description. But I must warn that it is getting messy from the sheer amount of detail. It's not even comprehensive yet. It includes links to the Australian Constitution, which everyone should download and read. The font and layout make it look modern. In the previous episode, I emphasized how we must be careful when using English words and concepts to make judgments about Indigenous concepts. Where there is an English legal term, and its definition seems to extend to an Indigenous concept, as expressed in English, it can't be assumed to simply be equivalent. Is the way that we understand ancient laws really accurate? Insufficient rigor in understanding the culture and languages could lead to injustice. Another reason why I think the voice is needed to research, preserve, and advise on these matters. We must remember that a decade of debate on recognition has led to this, and that the Uluru Statement came from an intensive 6-month deliberative process, and the outcomes of the regional dialogues were brought before the more than 200 delegates at the National Constitutional Convention over 23 to 26 May 2017, which reached an extraordinary consensus regarding voice, treaty, truth. We must not forget that Indigenous people have a unique status as the descendants of the first peoples of Australia, which comes with rights to land and heritage and more. This is the same under developing international laws and practices, expressed as the right to self-determination. As a minority within Australian society, they are also distinguished by their cultural diversity. They have experienced historical injustices by the government, such as land dispossession, the forced removal of children, and other horrors of the 20th century, with long-lasting impacts shown in statistical indicators, showing them as the most disadvantaged. These are facts, and I think these differences should be considered when making laws and justify beneficial, targeted measures. Disability rates are also very high, and the First Peoples population is projected to reach 1 million by 2028. So what are we going to do about all this? Surely not nothing. Also consider the theory of triple citizenship, including Australian citizen under the 2007 Citizenship Act, membership of the descendants of the First Peoples determined by the tripartite test from Marble No. 2, ancestry or descent, self-identification, and acceptance by the relevant community or group, and racial status under the Race Power, Section 51(26). Another category of non-citizen, non-alien, or belonger, as described by Justice Edelman, can potentially be relevant too. For some time I have been thinking about how we can present federalism, which is about relations between collective agents, and citizenship, which is about relations between individuals and the state, in a way that encourages everyone to reconsider treaties, reserved seats, and new states, and the voice, or similar options, as achievable reforms for Australia, especially because these features of Australian political traditions, like citizenship, are at first glance irrelevant to arguments for and against Indigenous struggles for justice. I want to explain why the voice does not create two classes of citizens. It only provides a platform to make representations. But this privilege provokes resistance because it is based on ancestry. While it's perhaps not possible or logical to equate citizenship and race, at least despite both sharing the characteristic of descent, one can say that drawing distinctions based on descent is legitimate. The use of descent as a criterion for citizenship is a widespread practice globally, including in Australia. The distinctions created by the voice need not be based on race, but can be based instead on a category called First Peoples, which Chief Justice French has been explaining for more than a decade now. The First Peoples category is based on descent, but it is, in any case, many races, not a single race, if the term race must be used. Citizenship has been around since 1948 and is taken for granted and not opposed as a racial practice. It also confers special rights based on descent. So the point is that it's really difficult to understand why a voice needs to be described as enshrining race into the Constitution, which already has two discriminatory sections dealing with race anyway, when there's the term First Peoples of Australia, which is included in Section 129 but wording, and is based on descent, a way of sustaining the political community, just like citizenship has done. This then relates to another reason put forward by Chief Justice French to support a constitutional voice instead of a legislative voice. By emphasizing that the voice is not about race, we should create a voice based on the First Peoples, rather than legislation based on the race power. It's not about race, or it doesn't necessarily have to be about race. Our vote becomes a first act of recognition and creates a democratic mandate to support independent and fearless advice and lessen the likelihood of abolishment. Our endorsement enables the voice to hold government accountable. While the voice could be legislated, it would be based on race and lack true independence to provide uncomfortable representation. It would be susceptible to suppression and abolition, hindering incremental improvement. It would also fail to fully respond to the earlier statement, and the momentum for a future referendum would disappear. Regarding the idea of achieving a treaty, sovereignty, or self-determination, splitting the nation or requiring the nation to make a treaty with itself, Dr. Lino argues that Australia's constitutional system is founded on the federal principle where multiple political communities are constitutionally recognised, creating a fractured sovereignty. So there is no indivisible sovereignty to divide in the first place. Australia has already made a treaty with itself called the Constitution. The Latin noun fedus is where the word federal comes from, and it refers to a formal agreement or treaty between states or peoples. What's the reason this should not extend to include political communities that have existed for millennia? It would be transformative, but it is nevertheless consistent with federalism. Federalism is about self-rule, where states like New South Wales and Victoria govern themselves, combined with shared rule, where states govern with the Commonwealth together. We can view the voice and reserved seats fitting squarely in the shared rule category, while treaty overlaps both self-rule and shared rule. The self-rule aspect of treaties can be about land rights, jurisdiction, principles, and duties. The Senate represents the interests of states, which are self-determining political communities, and the voice shares this federal spirit. Unlike states, the political communities represented by the voice have no geographical boundaries, but with some effort and negotiations, an updated map may be created, or a non-territorial federalism could achieve union without unity. Federalism can innovate and be flexibly defined to suit indigenous structures. On a side note, the expert panel years ago observed limited support for reserved seats. I wonder why the idea of reserved seats is so unpopular when it could be done using legislation and avoids the problem of indigenous politicians having to represent the interests of their non-Indigenous electorate. We can still have both. It guarantees some form of representation for the First Peoples that provides a different perspective from that of the voice. It appears that the voice won't be allowed to speak on the floor of Parliament. As so many people have said, the voice is constitutionally congruent and modest, fitting and furthering the Constitution's principles and values, leaving the existing Constitution unchanged. But it also provides a modest means to work towards consistency between the laws, towards equality and understanding between the parties, as we discussed 2 episodes back. But the voice it creates inequality between First Peoples and the people, you say. Well, many people have said that our Constitution does not value equality. As Professor Toomey also explains, the value of votes for the Senate is unequal. Each state gets 12 senators, regardless of its population size. Equal representation of states is prioritized over equal voting power of individuals. Similarly, we are prioritizing the political community, First Peoples, over individuals' rights. Tasmania gets many times more value of representation than New South Wales. The Constitution does not treat people equally. In terms of Section 128, the will of the majority has historically been overruled by the will of the 3 less populous states. In Section 128, it gives a state the special right to consent to changing its state borders or political representation. Section 96 allows the Commonwealth to provide grants, but not necessarily by distributing equally among the states. Yet taxation must be applied equally under Section 51(2). Recall the White Australia policy, the aliens and race powers, dual citizenship under Section 44, Aboriginal people under the repealed Section 127. It's not about treating everyone the same way. Treatment would differ between children, adults, the disadvantaged, even if there's a shared objective standard, because the level or type of treatment needed to reach that standard will differ. Anyway, it is widely accepted that equality must be substantive and not formal. Restricting donations or powerful voices, or enhancing disadvantaged voices through a voice, actually enhances equality. So, let's get started. In a webinar last December, you were asked whether recognition undermines or extinguishes sovereignty. Is sovereignty about independent statehood, or is it spiritual? Or what is sovereignty anyway?
Sure, yeah. Thanks for the question, and thanks for the invitation to be interviewed. It's a great pleasure. I think you folks down in Adelaide are doing some really amazing work around the voice, we look at your work with some envy from up here. I want to start by acknowledging as well that I'm coming to you for this interview today from the lands of the Kombumerri people and the Yugambeh speaking peoples of the Gold Coast. And I want to pay my respects to them, acknowledge that their land was taken without their consent, without compensation being paid over it, and without sovereignty over it ever being ceded. So that, I guess, is a segue into your question around sovereignty and how we can think about it. I think if we go to a very high level of abstraction, we can think about sovereignty just in terms of some kind of basic or fundamental form of political and legal power. Now, that's a pretty broad and vague notion. And I think once you start going beyond that and trying to give it some more definition, then it starts to get more complicated. The reason is because different people at different times have used the concept of sovereignty to do different things. And so we have various kinds of ways that the language of sovereignty gets used, various definitions, which are overlapping, sometimes in competition or in conflict with one another. So, moving away from that kind of broad, general, highly abstract version, just, a way of referring to some fundamental sense of political and legal power. I think we can think about sovereignty in different state sovereignty, the one that we sometimes hear politicians talking about, that we don't want anything to, violate Australia's sovereignty, or, we're not intending to take away from some other country's sovereignty or interfere with their sovereignty. Basic idea is that it's a form of legal and political power that's possessed by some nation state, understanding sovereignty more in a kind of internal sense, right? Internal to the government of a particular political community, particular state, which would define it as something like absolute lawmaking and political power. And in that sense, it's, today we would see in, modern liberal democracies, this idea of sovereignty being one that is possessed not by the state, but by the people, right? So this is the idea of popular sovereignty. The people, this abstract idea, the people ultimately possesses absolute political and lawmaking power, and they kind of lie behind the state, give it legitimacy. But if, they decide to, the people can kind of rise up, sweep away the state and create a new one in its place, because they're the ultimate repository of this sort of basic political and lawmaking power. Another way of understanding sovereignty that comes up in the context of discussions around the voice, around the Uluru Statement, around treaty, is First Nation sovereignty or Indigenous sovereignty. And that idea of sovereignty is one that is also about political and lawmaking power. It's about First Nations people's groundedness and connections to country, like long-standing, deep connections to country. The Uluru Statement talks about those connections as having a spiritual component. And the Uluru Statement also talks about the potential for this form of sovereignty to be one that coexists with the sovereignty of the Australian state. It's something that can be exercised at the same time. It can be sort of shared, it talks about. So look, those are some different definitions of sovereignty. And I think part of the reason why it's such a difficult concept is because we have all these different ideas that don't necessarily always speak to one another, and it's not always clear which version of sovereignty someone is using when they're using it.
Thank you for sharing that insightful perspective on sovereignty. Your description really highlights the complexity and multiple dimensions of the sovereignty concept. Its various interpretations suggest that its meaning can differ depending on the context in which it's discussed. I sometimes wonder whether this diversity of meaning poses challenges to achieving meaningful reform. Different layers of sovereignty can intersect, but also exist independently, as discussed 2 episodes ago. The notion of popular sovereignty in modern liberal democracies, where ultimate political and lawmaking power rests with the people, provides a foundational principle for such systems. It emphasizes the people's role in legitimizing the state and underscores their potential authority to bring about change if they deem it necessary. That's what maybe supports the ideas discussed 2 episodes back, where we shared a basic vision of 2 legal systems believed to be incompatible, working together effectively. And while it's not easily achieved, yet it's not a complex concept at all. We can do it, and the voice is just a tiny step in that direction of a 1,000-mile journey, a beginning. The voice can bridge the laws and cultures and bring the indigenous spiritual connection to the country that has existed for 65,000 years or longer into the mainstream, where it can coexist with the sovereignty of the Crown, where it can shine through to express Australia more fully and address the torment of powerlessness. Embracing diversity, preserving unique laws, cultures and wisdom, upholding Indigenous people's self-determination rights, focusing on celebrating this and other positive achievements because of Makarrata concludes the struggles and disputes which perhaps do not need to be mentioned or raised ever again, respecting the First Peoples each time we listen, demonstrating that justice can prevail over injustice, but that a strong will and determination enabled survival against all odds and will continue to do so. The existence of a closing the gap strategy means that certain philosophical underpinnings are there. It would not align with having closing the gap to dismiss the voice and promote survival of the strongest, as if the past does not exist. Symbolic recognition fails to respect identity and peoplehood. Self-determination is a right that must be achieved to prove our respect. Past grievances must not be allowed to occur again. That is real respect. The voice is a limited recognition of sovereignty by increasing the capacity to express it, helping realize it in practice. Doesn't matter whether treaty or constitution is subordinate to the other or becomes the framework for the other. You've said that sovereignty doesn't depend on denial by courts, which see sovereignty as exclusive and not parallel. And it exists regardless. Otherwise, it wouldn't exist now. It can't be extinguished, because it was not recognized to begin with all those years ago and doesn't exist in the first place before this voice takes effect. Professor Irene Watson says that it inherently can't be extinguished because regardless of these reasons. But can you say with certainty that sovereignty continues to exist as a political claim against Australia? Wouldn't Australia be able to cite various actions as reasons not to recognize sovereignty? Wouldn't that potential of sovereignty being recognized be diminished?
Right, yeah. So I think what you're pointing to here is concerns raised by some people, especially people on the progressive side of politics who are skeptical of or even outright opposed to, constitutional recognition of First Peoples, including recognition through a voice, because they are worried that it might ultimately, lead to First Nations sovereignty being extinguished. So the way that I kind of think about this is we need to think about Indigenous sovereignty as something that, in order to be realised or effective, needs to be granted some kind of recognition within a particular legal system or legal order. And so we need to think about which particular legal system or legal order we're referring to when we talk about, worries of Indigenous sovereignty being extinguished, right? So under the Australian legal system, for instance, Indigenous sovereignty isn't recognised in the first place right now, right? So the idea that a voice could somehow extinguish Indigenous sovereignty, it doesn't kind of logically make sense, because Australian law doesn't recognise that sovereignty in the first place, right? You can't extinguish something that doesn't exist in the first place.
I see.
Similarly with international law doesn't recognise Indigenous sovereignty. It's something that's, recognised as existing in nation states. And so the idea that Indigenous sovereignty would be ceded or extinguished by First Nations peoples supporting constitutional recognition through a voice, it kind of also confronts this basic problem, which is that Indigenous sovereignty isn't recognised under international law in the first place. And then finally, if we're thinking about Indigenous sovereignty under Indigenous law, from everything that First Nations legal scholars say about Indigenous sovereignty under Indigenous law, it's something that exists and continues to exist regardless of what Australian law or international law might say about it, right? It doesn't matter that Australian law denies the existence of Indigenous sovereignty. It doesn't matter that international law denies the existence of Indigenous sovereignty, at least insofar as its existence is concerned under Indigenous law, right? So, it exists right now despite the fact that both Australian and international law deny its existence, and it will continue to exist, regardless of whether or not we have a voice enshrined in the Constitution. I don't know if that answers your question.
Absolutely. If a legal system doesn't currently recognize indigenous sovereignty, concerns about extinguishment may not logically apply. In essence, you're underlining that something cannot be extinguished if it isn't acknowledged to exist in the first place. So I've cleared up my misunderstanding of the nature of sovereignty recognition. But in the future, could indigenous sovereignty be recognized?
Yeah, I mean, so in the future, could indigenous sovereignty be recognized under Australian law or under international law, say, right? Because it's already recognized under indigenous law. In the future, could indigenous sovereignty be recognized under Australian law or under international law? Yes, of course. Yeah. And the ultimate obstacle to that happening is a political one, right? The Australian government could turn around tomorrow and do various kinds of things through executive actions or through legislation which formally recognize indigenous sovereignty. And, regardless of what the Constitution says or does not say about First Nations peoples, right? So to give you an example, the attainment of state sovereignty, sort of sovereignty in that international law sense, a kind of full legal independence for Papua New Guinea, occurred by virtue of legislation passed by the Commonwealth Parliament, as well as acts of executive recognition by the Australian governments and other international governments, recognizing Papua New Guinea as a sovereign state. Prior to that, Papua and New Guinea were Australian external territories, right? They were kind of part of the sovereign system of the Australian state. And the only obstacle to that happening was political, right? Australian governments could have done that much earlier, and the reason they didn't was for political reasons. And so the same point applies to First Nations sovereignty. The only thing standing in the way of recognizing Indigenous sovereignty is a political one. And so sure, maybe in future a government might say to First Nations people seeking formal recognition of their sovereignty under Australian law or under international law, oh, well, no, we're not going to do that because, you agreed to a First Nations voice in the Constitution, right? And that's just, part of the, the political debate, around these kinds of questions. But equally, they might say, and there might be, a justification for saying, well, you've already recognized that we have a degree of political and legal power through this voice, but that's not enough. That's an implicit recognition of our sovereignty, our peoplehood, our right to self-determination.
Yes.
And you actually need to be going further than that.
It's clear to me now that the primary obstacle to recognition is a political one. Papua New Guinea's attainment of state sovereignty involved political actions such as legislation and executive recognition. Anyway, as the Australian National University PDF responding to common concerns says, how can non-Indigenous Australians cede the sovereignty of Aboriginal and Torres Strait Islander peoples by voting for a voice? Have Indigenous parliamentarians sitting in the Australian Parliament impliedly relinquished their sovereignty? How is it fair to cede sovereignty without doing so explicitly and formally with both parties' agreement? By default, Indigenous sovereignty can coexist alongside the Crown's sovereignty. It's not one or the other, so there's no risk of implied extinguishment. The real and ultimate injustice is that sovereignty isn't recognised. The fourth question in that webinar was what constitutional recognition is, and it is, to put it simply, respect for Indigenous identity within Australia's constitutional order. Conversely, Indigenous peoples also recognise their ongoing relationship with the settler state. The first question from the audience was about how to respond to lack of detail claims. We're voting on a voice that is not yet implemented or set in stone. Not just because the process for setting it up should ideally be a self-determined process, and it will take years and a lot of consultation and trialing and experimentation. But the 1999 referendum had too much detail and split factions resulted. So you explained that the current strategy is to avoid going beyond the high-level principle. Any disagreement should be based on that principle and not the co-design report or imagined scenarios. Details would be a bigger target, creating more reasons to oppose it. But there was a second part to the question, which was, what is the best or key purpose to explain to voters? And in the previous episode, I said it was to really be realistic about how Parliament would decide purposes, so we just decide whether the principle of having input into decision-making is appropriate, and how can it not be, since feedback is so important for improvement. That being said, supporters of the voice have to rely on their persuasiveness instead of criticizing opponents' ideas. It seems that the counter-arguments aren't punchy enough to defeat the opposing arguments, and it is very challenging to address hazy or unconscious doubts and what some call a lack of generosity. I'm sure many voters are insufficiently persuaded by the voice's predicted merits, none of which are guaranteed. The merits are just not expressed strongly and persuasively enough to dispel other concerns. It's also easy to adopt 21st century terra nullius. It's easy to clear things up without dealing with them, to give a standard response, to not change our ways. But listening and showing respect has such a small, yet profound, significance to governance and people's lives. And this becomes more apparent the more we know about what has come before. To make closing the gap on life expectancy, health, education, housing, and other key measures effective and accelerated, the principle of listening will be the constitutional law game changer. Parliament will be doing this, and we should support the government's efforts to address the disparities. We will always have a say in the voice design through ordinary elections. Is there anything wrong with governments being consistently better informed when making or altering laws or policies? We're just drawing a line to say to Parliament, do whatever you like, but there has to be a voice which may make representation. On a different level, Parliament is asking the people to pressure it to always listen to the feedback and wisdom of 3% of the population, because otherwise it's not politically feasible to consistently consult and listen, despite its effectiveness. When voters vote for this voice, it will become theirs, and surely will not let them down once it gets up and running, with decades of work and constantly dashed hopes behind it. And yet, this is the final hope, the final chance to reverse the life or death situations we can't even imagine. It's no time to be complacent or indifferent. I urge everyone to get informed, including by reading the key sources instead of the media coverage, and if you like, sharing legal podcasts about the voice across your networks. The purpose of the voice is to have ongoing recognition, not a once-off recognition preamble or an abolished ATSIC, or like the Legislative Recognition Act 2013, which expired, and to reset the Indigenous-settler relationship to address systemic injustice by passing laws together for Indigenous advancement. It will de-racialize, not re-racialize the nation. You've written that non-Indigenous peoples of states like Australia have more or less got customary international law self-determination. It can be assumed, but due to long-standing exclusion, Indigenous self-determination rights haven't been achieved, including decision-making participation under Article 18 of the UN Declaration on the Rights of Indigenous People. The voice is about recognition, a new relationship, and self-determination. Why is collective Indigenous autonomy not seen as a solution? Are the current passive failures satisfying? If we're serious about solving problems, we need serious solutions. The voice is low risk, high return. Moving along, why is self-organization or taking the initiative to create a body not set up by the government not possible? The National Congress ran out of funds, but could a voice be a government body that takes on the character of self-organization, so that a simple pros-cons comparison between self-organization and government organization isn't applicable?
I guess what you're getting at is the potential for First Nations peoples themselves to go out and set up their own political institutions and do that in some way that is, I guess, more removed from, legislation passed by Parliament or formally enshrined in the Constitution. So kind of less a sort of a state institution, I guess. So yeah, sure, that's completely possible to do. And First Nations people do that in various ways at the moment, and have done that for 100 years or more within the kind of the context of, settler political and legal system. Of course, they have self-organized for many millennia prior to that in their own customary ways, and continue to do that as well. So that is just, happening, but not necessarily happening at the scale of a kind of a national First Nations voice as envisaged in the referendum proposal. So a few things to say about that. If that kind of self-organized institution is going to be cognizable to the Australian state and perhaps, have various kinds of rights and capacities under Australian law, then it's going to be also subject to various forms of state oversight and regulation. So in particular, thinking about, taking on a corporate form, which is, what a great many First Nations institutions do today. There are thousands and thousands of them operating at the moment. And taking on a corporate form means you have to, satisfy certain accountability requirements to Australian state institutions and regulators. You have to constitute yourself in certain ways, right? So that kind of self-organized form doesn't sort of free you entirely from state oversight and regulation. And there's also, issues to do with finances as well, right? What's the kind of the political economy, if you like, of Indigenous self-determination and self-organisation? Where does that funding come from? And how secure and stable is that funding? And what we saw with the National Congress of Australia's First Peoples, which was a national corporate body rather than a body sort of specifically set up by Commonwealth legislation. What we saw with the National Congress is that it was, it too was dependent on Commonwealth funding and goodwill. And when we had a change of government from Labor government to Liberal National government, the funding started to be cut quite dramatically and ultimately resulted in the National Congress going into voluntary administration. So I think the attractiveness of going down the route of a legislative body that is also given constitutional status and constitutional protection is you can also maybe make a stronger case there for guaranteeing forms of funding security that you might not have when you're just a kind of a corporate body, existing under Australian corporations law and dependent on, the goodwill of grants from the executive government.
So the idea of setting up institutions that are more distinct from state institutions and formal constitutional enshrinement is certainly feasible and has been a part of Indigenous strategies for self-organisation for a long time. But there is very little beneficial difference between that and bodies like The Voice. The Voice is the only practical model for effective representations to be made, at least for now. I think The Voice won't be another bureaucracy. It can be forced to be active, not passive, for its own survival. And it's not imposed top-down by the government. We asked for it. Next, regarding vexatious litigation, we know the scope of representations under Section 129(2) is broad on purpose, because not everything is going to be about the race power. Criminal or health law and policy might require advice, which will be persuasive if it disproportionately impacts voiced constituents. Also, we can't predict what topics require advice decades from now. Broad wording also means nobody would be wasting time trying to test whether a representation fits within a narrowly defined scope. And that would not be litigation over a law, but just a powerless representation that isn't going to do anything. Similarly, why would the executive be affected at all, given that all of us, including The Voice, can make representations to the executive, an action which is protected by the implied freedom of political communication? They have discretion to ignore, or Parliament can work out the specific mechanism which will be efficient and not burdensome. And The Voice must prove its usefulness to maintain the funding and legitimacy and achieve actual outcome. But would Section 129 give rise to a duty to consult and give all information necessary to enable representations to be made? Would there be a positive right to information? Is this not taken for granted? And if it's not, why is it emphasized as if it's a bad thing?
Let me take the second point first. I think in terms of a duty to consult, a duty on the executive government or certain parts of the executive government and on the Parliament to consult with First Nations peoples prior to making decisions that affect them, I think that would be a great thing. I think that would be, a fantastic thing to institute in Australian public law.
Absolutely.
And this is something that already exists in other jurisdictions. Canada is one that's perhaps most familiar, at least with respect to executive decision making. And it's something that is seen as a kind of a basic standard of the human rights of Indigenous peoples under the UN Declaration on the Rights of Indigenous Peoples. The kind of a duty to consult with a view to obtaining Indigenous peoples' free, prior and informed consent when decisions are being made that affect them. So yeah, I think it would be a great thing, personally. In terms of Section 129 giving rise to such a duty, I don't think so. I don't think that there's a warrant in the text of that provision that really suggests any kind of legally enforceable duty on the part of the executive or the parliament to consult with First Nations peoples. That's consistent with, esteemed legal commentators who have looked at this, or at least I would say the vast majority of legal commentators who have looked at this question, that there wouldn't be any kind of obligation imposed to consult First Nations peoples. That being said, legally enforceable duties are not the be-all and end-all of public law, and we have within our constitutional arrangements various non-enforceable duties and rules that are nonetheless deeply entrenched customs of political practice. We call them constitutional conventions, and these govern the actions of especially members of the executive, senior members of the executive government, ministers, the Governor General, the Queen, and so on, about what they can do, mostly related to responsible government. And in the context of a successful referendum, and perhaps as a result of maybe changes in executive government policy, perhaps changes in parliamentary standing orders, you can envisage various forms of political obligations, political duties to consult being instituted, which wouldn't be legally enforceable in the courts, but which would nonetheless be developed to guide the political practice of executive and legislative actors, and which could be powerful ways of guaranteeing First Nations people a right to be consulted and listened to.
The intention behind Section 129, including from the explanatory memorandum and the second reading speech, doesn't support such implications. There's no gap to fill, no logical or practical necessity to draw an implication. There's nothing new in any of the other words either, merely restating facts. Regarding all worries about the uncertain and risky voice, any part of that worry related to the future legislation is not important because Parliament can change legislation where it doesn't work well. So a lack of details creating uncertainty is not a reason to dismiss the proposal, which is only the principle. This constitutional change is not zero risk, but it is very low risk. Where is the problem with inserting another interstate commission with a different name whose function is to make representations? The real risk is instead that the voice becomes another interstate commission, another ATSIC. Administrative or constitutional law litigation is normal, and the floodgates thinking style is laughable, and people will naturally disagree with court decisions, but none of this is special or capable of being persuasive reasons to avoid beneficial constitutional change. The voice came about to avoid going to the courts to enforce rights, long after the policy has become law and impacted adversely. It wouldn't look good to then go to the courts over it without very compelling reasons. It would be nice to see non-legally enforceable constitutional conventions develop over time. You suggested in your book that directive principles of state policy could foster constitutional conventions relating to the voice. And there are many ways the government can influence constitutional culture that's not within the control of the people. The voice can help steer that influence in the right directions. Next, the voice will be in a new chapter 9. The minister's second reading speech said that this reflected an intention to begin a new chapter in Australia's relationship with the Aboriginal and Torres Strait Islander peoples. The idea was to give it separate constitutional status, to speak to the institutions of the other chapters, and ensure independence, including of funding, to enable representations and free, prior, and informed consent. Does this give it a structural prominence, important when interpreting it, and create implications for the relationships between the voice and the institutions in chapters 1, 2, and 3?
So the question was about whether there are constitutional implications that can be drawn from the structural factor of the voice being in its own chapter in the Constitution. Yeah, so one of the methods of constitutional interpretation that the High Court deploys when it tries to understand the meaning of the Constitution is to look at the Constitution's structure. And that can mean looking at provisions of the Constitution as they relate to other provisions of the Constitution. Also mean looking at a more macro level at, things like chapters and what goes in particular chapters. The most familiar structural implication that people might know about is the one drawn from Chapter 3 of the Constitution, and the High Court basically saying the fact that the federal judiciary being separated out in its own chapter, Chapter 3, provides an implication that the judiciary needs in some fundamental ways to be separate from the other political branches, the executive and the parliament. So that's the kind of structural argument that's perhaps the most familiar and the strongest one that we have. In terms of structural arguments about the voice and it being contained in this new Chapter 9 right at the end of the Constitution, it's certainly possible to make structural arguments. That's something that the High Court accepts. It's not entirely clear to me what kinds of structural arguments you would make about the fact that the voice is in its own chapter, let alone the likelihood of those succeeding in the High Court, the High Court drawing some kind of structural implication from the fact that the voice is in its own chapter. Maybe, possibly something around the voice needing to be independent of the other branches of government in certain ways. Maybe that could be something you could draw from it, like the judiciary. And given the fact that the voice is supposed to be making representations to the executive government and the parliament, suggests that it's supposed to in some ways be outside of those institutions. So, perhaps there's some kind of structural implication that you can draw there. But I think, the High Court is pretty wary of drawing implications ever since the engineers case. And so structural arguments have really fallen out of favour, over the last 100 years. Not to say they aren't made and can't be made, but they're not ones that the High Court, it's not the kind of the main interpretive method that the High Court deploys.
So the High Court's approach to constitutional interpretation regarding Chapter 3 and the separation of the federal judiciary could similarly apply to keep the voice independent, but there's little else, and structural arguments aren't in favour these days. In the previous episode, we talked about the defunct Interstate Commission, Section 101, but it is not in its own chapter. Apparently has more detail about composition, and although nobody except the Attorney General is likely to have standing to challenge the Interstate Commission's absence, based on the Federal Court of Australia case in 2014, Lee and Commonwealth, the voice's absence or abolishment could be challenged by a voice member. Of course, realistically speaking, the Attorney General wouldn't be challenging the Interstate Commission's absence. It might be that nobody is likely to have standing to bring back the Commission. Standing for the voice is much more likely. But these differences aren't fatal to what I said previously. I think the Interstate Commission's history still suggests that the voice can risk becoming a ghost, and it also supports the argument that there'd be no need for sunset provisions, once mentioned in Chapter 7 of Professor George Williams' book People Power, to kick in once the purpose of alleviating disadvantage and so on is complete or has failed. The Interstate Commission was created and is mandatory, so its repeal was possibly unlawful, but the Interstate Commission's initial establishment was said to be unenforceable by a court because it is a duty of imperfect obligation. For the voice, however, once it's established, complete abolishment is unlikely. I wonder whether there is any difference between the general legislative power used to abolish the Interstate Commission and the power in Section 129(3) to make laws about the voice, which might not be able to validly abolish the voice. For our purposes, it's just the words, subject to this Constitution, that makes the voice different from the Interstate Commission. I wonder, legislative power isn't only subject to what is expressly stated in Chapter 1, but to all provisions and implications. The result is that there will always be a voice once there is a voice for the first time, but it can still be made into a body in name only. It's also unlikely that the High Court would have any major influence over Parliament's decisions over the voice. Professor Gabriel Appleby and Professor John Williams wrote that public support is key to having the voice enacted for the first time, as there's nothing else to compel its enactment. Even then, there's no guarantee. Also, that the voice's constituency, its voters, would encourage its survival only if they view the voice as legitimate. The voice design is constitutionally congruent with parliamentary sovereignty, unlike the inconsistency between the Interstate Commission and Chapter 3. The voice could either be viewed as a threat or as a valuable body, but first we need the courage and intergenerational generosity to get it up and running. Using lessons from the Interstate Commission, ATSIC, and similar bodies found overseas. It's up to us in the future to keep things running smoothly. So, at the end of each of our episodes, we like to ask some questions that are a little bit more personal or controversial, and we call this segment Speak Your Voice. Can you shed light on how the Constitution and its values should ideally be viewed by Australians today? Is it outdated, unrelated to our lives, or should we view it as something that is more political, since it's so often in the news now that the way we see it seems to have changed?
Well, the first thing I would say is just that the Constitution is an institution that is fundamentally political. It's fundamentally inflected with values, and those are particular kinds of values that are preferenced over other kinds of values. So that's a kind of an unavoidable fact about having a constitution, and I think that's in some senses, or for some people, a controversial statement to make. They like to think about the Constitution as just this politically neutral kind of document. It doesn't have values, especially because it doesn't have rights in it, and so in that sense, you can say, oh, it's just this politically neutral institution, and I think that's just bullshit, to be frank. Look at the people who drafted the Constitution. Look at the kinds of things that they were hoping to achieve with it. Look at their political background. They were all politicians, right? Liberals and conservatives, politicians. They were all men. They were all white. They were all settlers. They were all professional or wealthy people, and the values of those people inform the Constitution. That doesn't mean that those are necessarily the ones that continue to inform it today. The Constitution evolves, as a result of different ways it's interpreted, different ways power is exercised under it by the different institutions that it establishes. But, the Constitution is a document filled with values. Now, in terms of how we interpret those values, I think it kind of depends on your politics. And so if you look at people who are on the more conservative side of politics, they will see embodied in the Constitution values that they really admire and celebrate. They see it as this kind of great embodiment of the kind of the practical spirit of the Australian people. We're a pragmatic people. We don't sort of go for highfalutin statements and aspirations. We just get on with the job, and we've got this great genius for, democracy and the rule of law and all this sort of thing. That's a kind of a liberal conservative tradition that you can trace back to sort of British political thought. For people like me, who are more on the progressive side of politics, I think we see the values, a lot of the values embedded in the Constitution, not the only ones, but a lot of the values embedded in the Constitution as ones that are troubling and outdated, right? And ones that don't fit our vision of what Australia is today, or should at least become. And so it goes back to, those foundational values around racism, around settler colonialism, around patriarchy. And I guess also the kind of more conservative sorts of institutions and the ways that for me at least, the Australian Constitution operates. Those aren't ones that I think we should be celebrating today, and we should be injecting it with other kinds of values around democracy, equality, fairness, and experimentation too, right? And I think the voice fits within those values.
Your explanation of the Australian Constitution's inherently political values and the interpretation of those values through different political lenses provides a thought-provoking perspective on the document's nature and implications. Depoliticizing the Constitution hinders its evolution through interpretation and use, preventing it from keeping up as society changes. The voice seems to appeal to the practical view because it is not purely symbolic, to the liberal view because equal rights can remain undisturbed, to the outdated view because it balances the race provisions with First Peoples, and to the exclusionary view because it inserts the term First Peoples of Australia. The more people that understand the Constitution and carry it around, the better our chances are of transforming it carefully in appropriate directions. Now, what are some of the reasons that make your academic field fascinating to study?
Well, I mean, it depends, which academic field we're talking about. But in terms of constitutional law and its intersection with First Nations rights and interests, which is, one of the main things that I've focused on throughout my career. I think what attracted me to constitutional law is the connection, but the very clear connection you can see between constitutional law and politics. And for me, politics is a really important, thing that we need to be thinking about. And we, as lawyers, we need to be thinking about how the law is shaped by politics and how the law in turn helps to shape it. So I think for me, that was the attraction. But of course, every field of law is political. Every field of law is shaped by and in turn shapes political outcomes. So I think it was just easier for me to see when I first started studying law that constitutional law had that political connection. In terms of First Nations rights, for me, I think it's because I guess I hold more progressive political views, it's really concerns with the way that the Australian legal system has oppressed and discriminated against First Nations peoples from the get-go and continues to do that today. And so it's kind of trying to understand that and take responsibility for that as someone who is a citizen of this country and who in many ways has benefited from those forms of oppression and discrimination against First Nations peoples, and also as a lawyer who has some professional responsibility to understand that. And then also thinking about ways then that you can take responsibility for that law in trying to transform it in more emancipatory or progressive directions in keeping with the aspirations of First Nations people.
Yeah, law doesn't exist in a vacuum, and we all have ethical and civic responsibilities that we must fulfill. Thank you so much, Dr. Lino.
Okay. No, absolutely. They were a great set of questions. Really glad to be here and chatting with you. And you've clearly done your homework. So yeah, thanks for some tricky questions.
Thank you.
No worries.
Thank you again for answering my questions today. Thank you especially to each and every listener joining us for this episode of the Heart to Heart podcast bonus episodes. You can reach out to our socials linked to in our main Heart to Heart campaign website and ask us any questions about the 2023 voice referendum. Thank you for listening to us.
All right. Cool. Okay. Thank you very much.
You're very welcome. I'm very happy to have experienced this interview. Thank you for adapting to the recording technology when things don't quite work and for allowing me to go over time for this recording.
Sure. All right. Great. We'll keep up the good work.
Definitely.
All right. See you later.
See you later.
Bye.
It is important to acknowledge that constitutional recognition is just one vital part of ongoing initiatives like truth-telling and treaty-making. The voice serves as a feedback mechanism that prevents wasted resources and ensures efficient, open, and effective decision-making. A no vote rejects generous compromises and perpetuates injustice by shutting down all political possibilities. A yes vote requires vigilance to ensure promises are kept. As Chief Justice Gleeson explained, if the client is the voice's electorate and the lawyer is the voice and the court is Parliament, then the court benefits from the lawyer's help in enhancing the court's capacity to make a transparent, just decision efficient. We benefit from this, even though the case is unrelated to us, and we will likely benefit in the same way from the voice assisting Parliament. It is not a voice which only benefits the First Peoples, and we've got to stop abolishing the lawyers and instead allow them to improve. In many ways, the proposed voice is inseparable from constitutional recognition. The definition of constitutional recognition has moved on, and arguably one can't convincingly take issue with the voice while excusing oneself by pledging support to an outdated legacy model of constitutional recognition. There have been years and years to do old-fashioned constitutional recognition, or even a legislated voice. Symbolic recognition has been rejected by the 1999 referendum and by the Uluru Dialogues. Whatever changes are proposed, there's going to be the naysayers. I ask, how can more people feel like they own this voice? Is it not something that you're happy to support, you're proud to vote yes for, something you view positively with hope for the future? Apart from the discomfort and indifference, surely there must be the general desire to right wrongs. History could have been different. Marlborough No. 2 might not have provided the best result. Sovereignty could have been addressed at a different place and time, just as the future has many options. We never went far enough, always treating beginnings as an end, and must now stop the cycle, reset Indigenous-settler relations, recognize our lack of spiritual affiliations, that it's our problem, not just one party's. Criticism of closing the gap makes people reactive and passive, so we need to completely transform the foundations. We must ask, as Professor Watson has, what makes us human and how is that determined? What it is to be human. For the first peoples, it is their connection to land. 3% of the world's population is looking after 70% of the biodiversity, languages, cultures, and by denying their human rights like self-determination, we are preventing them from meeting their responsibilities, including to care for country. In so doing, we are denying the humanity of the first peoples, rendering them not human. We ask ourselves, what makes me human? And it is perhaps that we can change to know ourselves differently by adopting a new common sense. It is apparent that Australia is without lawful foundation, and that Western law has no connection with the land. We are asked by the first peoples, by what lawful authority have you come onto our lands and breached our laws? We have a chronic legitimacy crisis, but also a possibility of incremental progress on sovereignty issues through the voice and dialogue. Are we ready to move on from the colonial project, for the normalized and unnoticed Moldavi to shed its clothes, to remove its layers upon layers of masks, to relinquish all that it has unjustly taken, and then come and sit down on the ground to learn from the ancient ways and take collective action to solve problems and work out a way of coexistence? As Ms. Andrea Mason recommended, speak to young people and ask them what they think about the proposed voice, knowing that this change will impact them for longer and might just be an opportunity for future generations to endure less structurally caused suffering and disadvantage.